Hi David, now we're looking at Module 8. Can you tell us what this module's about?
Yeah, this module is about things like confidentiality, data protection, intellectual property and freedom of information.
So organisations have considerable responsibilities for data protection. Can you tell us more about that?
It's partly about record keeping. Organisations need to maintain robust records, and particularly around the consent they have from the individuals, and particularly where we're talking about sensitive personal data, which is any information under a range of categories, including whether someone has committed an offence or is alleged to have committed an offence. Organisations need to make sure they've got proper processes in place to ensure they're only holding information for the purposes they're permitted to hold it for, and they've got clear consent, particularly for what I call sensitive personal data.
And what happens if an organisation gets it wrong?
Well, a number of things might happen. One is that under the ISPA, all of the obligations of the contractor are pushed down to the subcontractor. So there may be a breach of contract problem, which may ultimately, if it's serious enough or if there are enough of them happening, lead to possible grounds for your contract to be terminated. That's one issue. Another one is that the Information Commissioner has very broad powers now to impose fines where there are breaches of data protection. And a couple of years ago, a charity was fined £70,000 for leaving some very sensitive information outside someone's door when they were meant to be posting it through the letterbox. So they got a very significant fine for that. And of course that can itself lead to very big reputational problems, as it did for that charity, because that was all over the charity press, as you can imagine.
And do people have the right to see the information an organisation holds?
Yes, individuals can request information that you hold about them, and you have to respond within a certain number of days. So it's very important that you're only holding information that you're clearly authorised to hold, and that you're not holding it for longer than you should.
So what about freedom of information? Do organisations have to comply with that?
Well, freedom of information law applies to public authorities, and at the moment, for example, that doesn't cover charities. But under the ISPA, the contractor's obligations are pushed down to the subcontractor, and there are requirements to respond within 5 days if you get a request from the contractor to help them respond to a request they've received. So indirectly, yes, there's an obligation to help the contractor comply with freedom of information.
And what about confidentiality?
Well, there are very broad obligations on both sides to maintain confidentiality about what's called confidential information under the ISPA. So you should really assume that anything within the contract is confidential. And if you've got particular concerns about wanting to disclose information perhaps in your annual report or in your marketing materials that might be confidential, you should just check and perhaps renegotiate the wording of that with the contractor. And
record keeping, what does an organisation need to be aware of?
Well, they should think about the issues we've already covered on data protection and freedom of information. They also need to think about whether they've got compatible ICT systems with the contractor, so they won't have any additional cost in maintaining those records. And in terms of how long they keep the records, I'd recommend they keep them for at least 7 years following the end of the ISPA.
There are broad clauses in the ISPA about intellectual property rights. What is intellectual property?
Yeah, what it means is that the law will help people to protect their creativity, if you like, in certain ways. So one of these is copyright. For example, if I take a photo or I write a chapter in a book and it's an original work that I've done, I've got copyright in that. And I will have to put a copyright notice on when I publish it. And it's important to remember you can't actually register copyright anywhere, so you've got to actually prove that you were the first person to create that thing, whatever it is. If I, say, had drawn a logo, there may be copyright in that, but I may also be able to create a trademark and register a trademark, either as a logo or some words or a combination of both. And that's a much stronger form of protection because you can actually register it and demonstrate to the world that you've done that. But I think people need to remember as well that just the way you work and perhaps some ideas you've had while you work are not necessarily going to have intellectual property protection unless you've sort of put it down into something concrete like some training materials or a software program, something like that, and there's copyright in it. Just the way you work on its own is not really enough to generate intellectual property rights.
So how do the clauses on intellectual property rights affect organisations?
Well, there are a number of things. One is that it's made clear that if either side's got pre-existing intellectual property rights, then they continue to own those rights, of course. Also that each side licenses to the other the right to use its own intellectual property rights, so there's a permission granted to use the other's rights. And finally, that anything created in working on the ISPA is owned by the MOJ, and they permit you to use it while you're working on the ISPA, but that subsequently you won't automatically have the right to use it. So if you wanted to have those rights, you'd need to negotiate that specifically.
And then how can organisations protect their intellectual property?
Well, on things like training materials, they should make sure they have a proper copyright notice in place, which would include their organisation name and the year they created it. And if there are things created during the ISPA that they may want to use following the end of the ISPA, they should try and negotiate with the contractor a variation to the contract that would let them use those materials following the end of the ISPA.